Well, it's so great to see so many friends, colleagues, people who, I've worked alongside with for many years in this anti-trafficking movement. So thank you all for being here. See a lot of folks with lived experience here. So grateful to have you in this space with us as well. And I know most of you do know me, but for those who don't, my name is Jamie Beck. I'm a human trafficking expert witness and consultant. I've been working with survivors for the last decade, spent 7 years running Free to Thrive, working exclusively with survivors of trafficking on a variety of legal issues. And I also teach at 2 law schools a course on trauma-informed legal skills. And I'm thrilled to be joined here with my colleague, Chelsea Estes.
Hello, good afternoon, everyone. It really means a lot to me to hear Jamie refer to me as her colleague because really she's been such a mentor and such a positive influence in my life. I started out as an attorney in San Diego at Federal Defenders, and through that work, I witnessed the prosecution of many victimized populations, but specifically was drawn to human trafficking victims and survivors in particular. And that's how I met Jamie. I met her through her work with Free to Thrive, and I worked with her for a year, working to vacate convictions of survivors. And it was just a remarkable experience for me. And I've taken that forward into my work. Now I'm an attorney at the Muslim Legal Fund of America, where I continue to witness patterns of criminalization of victimized populations. And I'm excited to be able to continue to work with Jamie in some capacity and be with you guys today to talk about some of our latest research and conversations and some things we're excited to get into.
Thank you, Chelsea. So just a quick roadmap of our time together. We're going to talk about the root causes of criminalization of victims. And, just a heads up, there's an asterisk there because we are going to use the term victims and we're going to use it for a reason. We're both immersed in the anti-trafficking space and we, often use the term survivor, thriver. But in this context, we're using the term victim because when somebody is being criminalized at the moment where they are still a victim or being victimized, really that's what we're talking about here. Somebody who is also a victim of crime and who's being charged with a crime or treated as a criminal in our criminal legal system. And victim in the legal system has a very clear meaning, and it comes with rights that come along with being a victim. And so it's really important for us to emphasize that the folks we're talking about are victims of crime and should be treated as victims of crime. So that I want to let you know about that. We're going to talk about common scenarios leading to the criminalization of victims. We're going to talk about the impact of incarceration and reforms, changes that have happened around the country to change the laws around this intersection of victim offenders or victims who are criminalized. And then we're going to conclude with some proposals on what it would look like to have a more trauma-informed criminal legal system. Our goal is to do this in about an hour. It may run over a little bit. We understand if you have to jump off. We do want to leave time for questions, and we're both available to stay on a little bit longer if we do run over the hour, but you all have questions that you want to ask. We're happy to do that. And, we hope this is the beginning of a longer conversation. We certainly cannot, this is just a high level overview of really complex, deep issues. And, we hope to have further conversations. This is also an overview of an article that Chelsea and I recently published in the Roger Williams Law Review. This is like the Cliff Notes version of what is a very lengthy article that goes a lot further in depth on these things. And we'll give you information at the end about how to get that article. It's pending publication really any day now, and we'll be sending that out to anybody who wants it. All right. So first, I know many folks in this space are familiar with Crystal Kaiser's story of one of many survivors who has faced quite a horrendous experience in the criminal legal system as a victim of trafficking. But for those who don't know Crystal's story, I'm going to tell you a little bit about her and her experience. Just want to give you a heads up that it's a really horrific story, and I just want to give you that warning, before I share a little bit about what happened to her. She was 16 years old when she met 33-year-old Randall Valaire. He sexually abused Crystal and also about a dozen other Black teenage girls. He filmed the abuse. He also sexually exploited her by selling her to other men for sex. She was a minor at the time, and therefore she was a victim of human trafficking under state and federal law. And this has been going on for about a year before his death. Now, in this case, there was extensive evidence of this abuse, which is often not the case. In the cases that we see, very often there's little or no evidence of abuse. But here, there had been video recording of the abuse and showing both Crystal's abuse and the abuse of the other victims. Now, after a year of abuse, she finally rejected Valer, and she shot and killed him after he attempted to sexually assault her. Now, prior to this happening, prior to his death, 3 months beforehand, another teenage girl who was 15 years old at the time called 911 from his house. She said that he had drugged her and threatened to kill her. When police came to find her and to find out what was going on, she was found half naked walking through the streets in Wisconsin in February. At that time, Valer was charged with sexually exploiting these individuals, and then he was released without bail. So 3 months beforehand, this happened. Police had seized all of this evidence. So the videos I mentioned, police had actually seized that evidence at the time of his original arrest and had it in their possession prior to his killing. And he was out on bail when he was killed by. And basically what happened is that, police were well aware of his abuse and really did nothing to intervene and stop what was happening. They arrested him, they charged him with a crime, and then they allowed him to continue to abuse children. In her case, she was charged with first-degree murder. And in her case, Ms. Kaiser argued that she was entitled to use Wisconsin's affirmative defense, which is for victims of trafficking. And the statute requires that the trafficking, the crime that they're being charged with, the offense, be a direct result of their trafficking. And she sought to use that affirmative defense in her case. And that case went all the way up to the Wisconsin Supreme Court. And the question was whether or not you can use this affirmative defense when you're charged with first-degree murder, or whether it's limited to some lesser crimes. And the Wisconsin Supreme Court agreed with her. It said that you can use this affirmative defense even in the crime of first-degree murder. And it set a really powerful precedent saying that survivors who commit crimes as a direct result of being trafficked should be shielded from criminal liability regardless of the crime. Nevertheless, Crystal Kaiser is serving an 11-year prison sentence. So if she's a victim of trafficking, why is she in prison? The reality is she faced a situation that we see many survivors facing across the country, which is she faced a district attorney who refused to acknowledge the fact that she was a victim and continued to aggressively pursue charges against her, even after all this evidence was there in her case, even after the Supreme Court said you can use this affirmative defense. The district attorney didn't drop the charges, didn't reduce the charges, and continued to pursue charges, which if she was convicted at trial, she would potentially face life without the possibility of parole, meaning this, young woman in her early 20s faced spending the rest of her life in prison because of this crime that she committed to protect herself from her trafficker. And so she did what was the safest thing to ensure that someday she would be free, which is that she took a plea deal. And she is now serving out 11 years in prison with following that 5 more years of supervision after her release. Now, she is one of countless survivors who are criminalized for crimes that are directly related to their victimization. And she did what I have seen, and I know Chelsea has seen so many survivors do, which is take a plea deal because that is the safest chance of having freedom at some point. And, we see folks in the criminal legal system, regardless of whether or not they're victims and survivors, do the same thing, which is take a plea deal regardless of culpability because that might be their only shot at getting out, or because there's really, really heavy charges being brought against them. and they are kind of rolling the dice if they take the case to trial. Chelsea, anything to add before I move on? Okay. Now the statistics on, who are the women in our jails and prisons are quite staggering. The reality is that the vast majority of women in jails and prisons are victims of some form of violence. And this data is all from the Vera Institute of Justice study called Overlooked Women in Jails in an Era of Reform. And it found that 86% of women in US jails and prisons are victims of sexual violence, 77% are victims of partner violence, and 60% are victims of caregiver violence. So what this means is that the vast majority of women that we are locking up are actually victims. And the data on men is a little bit different. The most there's still like a majority of men in prisons are victims of crime as well. Far less are victims of sexual violence, but many of them have very serious trauma histories prior to their charges. In addition, there was a recent study out of Stanford Law School called Fatal Peril: Unheard Stories from IPV to Prison, from the IPV to Prison Pipeline. And that came out last year. So it's a very recent study. That study looked at women incarcerated in California for charges of murder or manslaughter and found that a staggering 74% of these women were victims of domestic violence within 1 year of their crime that they're currently incarcerated for. And among those women, almost 2/3 of them were in very, very dangerous DV relationships based on an evidence-based measuring tool that measured their likelihood of being killed by their abuser. So these women were in lethal relationships. In addition, the research that we have around survivors of human trafficking, skewed towards sex trafficking as opposed to labor trafficking, found that 90% of sex trafficking survivors were arrested and charged with crimes related to their trafficking. Only 10% of folks in this survey by the National Survivor Network had never been arrested. 58% of them were arrested for the first time as adult, 42% were arrested for the first time as minors. So when it comes to victims of trafficking, we're seeing a staggering number face criminalization during their trafficking and as a result of their trafficking. And certainly that's what both Chelsea and I have seen in our years working with survivors. So let's talk about why this is the case. What are some of the root causes of the criminalization of victims? So there's a couple things happening here. One is we find that trauma responses are being criminalized. So when somebody is in a traumatic moment, your body in that moment tries to protect you and you go into what is called fight, flight, freeze, or fawn. Now, this is not a trauma training. That's a whole nother training that we could do on the brain science around trauma. But what we find is oftentimes the automatic functions in your body that are totally they're things that you don't think about that your body does to keep you safe in a moment where you feel either subjectively or objectively that your life is at risk or that you could be harmed. Those responses lead survivors to engage in actions that can be misconstrued as criminal behavior when actually they're really survival skills. In addition, we see a really high number of incarcerated folks, men and women, have extremely high adverse childhood experiences. And that's a whole nother conversation about adverse childhood experiences. For those of you who are unfamiliar with that term, ACE or ACEs, there's a study by Kaiser Permanente that studied the connection between childhood experiences and different adverse outcomes later in life. And what we find is that our incarcerated populations in the US have extremely high ACEs. And what that means is that these are folks who have had tremendous adverse childhood experiences. We see among the populations that we're talking about, victims of abuse, assault, and trafficking have disproportionately high ACEs as well. Now, one example of among so many is uh, Cyntoia Brown, who I'm sure many of you have heard a little bit about her story, but the version of her story that she tells of what happened. She's also somebody who was incarcerated for um, killing someone who was trying to assault her. She believed that he was trying to kill her, and she thought he was pulling out a knife. And so she responded in an instant to protect herself. And we see that so often in domestic violence, human trafficking, sexual assault cases where somebody responds in a way to protect themselves that is then characterized and treated as a crime, as opposed to something that is done to save one's life. Now, this really powerful quote from, if you all, it's another great resource. We include a lot of resources for you to, to learn more about the things we're talking about. The Sexual Abuse to Prison Pipeline, The Girl Story, this incredible study by Rights for Girls and Georgetown Law School, Center on Gender Justice and Opportunity, said, yet despite the body of research showing that the effect of trauma and abuse drives girls into juvenile justice, the system itself typically overlooks the context of the abuse when determining whether to arrest or charge a girl, often a minor, with an offense. And really, that's what we see. We see a lot of minors charged with crimes who are also victims. And just, one data point to, bring this home is a study that was done of girls involved in Oregon's juvenile justice system found that 93% of the girls in that system had experienced sexual or physical abuse, and 76% had experienced at least one incident of sexual abuse before the age of 13. What this means is that we are locking up child victims of abuse, and criminalizing them and blaming them for their own abuse and their own responses to that abuse. In addition to that, we also see the criminalization of poverty and addiction. And we see this across the board, certainly not just with victims in these populations, but we see individuals who are criminalized for, you know, things that they do to survive because of poverty, of needing to steal things or engage in sex work in order to support themselves and their families. Also, there's a huge intersection between trauma and addiction. And what we often find is that survivors often use substances to cope with their trauma and then are criminalized for possession or use of those substances, or even selling illegal substances as a way to make money to either address their need for income or their addiction. And then the same study I referred to before, the Vera Institute study, found that 82% of women in jail are there for nonviolent offenses, and specifically property offenses, drug offenses, and public order offenses. And so the vast majority of women in this country who are in jail are in jail for nonviolent offenses. And of course, we cannot talk about criminalization of any population, including victims and survivors, without talking about the systemic biases and systemic forms of oppression that we have in this country, including the disproportionate criminalization of folks from marginalized groups, including individuals from marginalized racial groups, our LGBTQ population, and also immigrants, all face disproportionate criminalization across the board. And we see that same disproportionate criminalization when we look at the criminalization of victims and survivors. And, in the work that I've done working with survivors, I've repeatedly seen the disproportionate impact of having survivors say, I was with a group of victims, and the victims who were white were treated as victims, and those of us who were Black were arrested and charged with a crime. And that is unfortunately pervasive in our society. And a data point on that is that there's a study of minors arrested for prostitution in California before California decriminalized child prostitution and aligned the law to acknowledge that a child cannot engage in prostitution because they're legally victims of trafficking. Prior to that happening, Black girls represented 70% of juveniles referred to juvenile court for probation for prostitution. And the reality is the demographics around victims of trafficking are much more evenly split between all races, but we see a much higher incidence among criminalized survivors of more likely to be African American, Latinx, particularly African American. And now I'm going to turn it over to Chelsea, who's going to talk about some of the common scenarios that lead to criminalization.
Thank you, Jamie. So this bleak reality that Jamie has described of victims being treated and categorized as criminals from the outset happens under all kinds of different circumstances. Today, we're going to focus in on some of the most common, including retaliatory violence scenarios, forced criminality scenarios, and crimes by association. So we'll start off by talking about retaliatory violence. One of the most common scenarios leading to the criminalization of victims is exactly this: acting out in response to a threat to your own safety and then being prosecuted for that criminal behavior. There are many high-profile examples in the media of criminalized human trafficking victims. I'm sure many of you will have heard of these and become familiar with these stories already. But our next slide is going to just go through a few names and cases where retaliatory violence is what led to the arrest, the criminal charging, and the sentencing of survivors. So Jamie has mentioned Crystal and Centoya's stories already. Sarah Cruzan is another example. She was also a victim of child sex trafficking, and she shot and killed her trafficker when she was 16. And notably, this trafficker was an older man who began grooming her when she was just 11 years old. And despite all of that information being available in her case, she was convicted of first-degree murder and sentenced to life without parole. Next, there is another example we can point to, Keena Aldrich. Jamie, would you mind going to the next slide? Thank you. She also killed her trafficker when she was only 16 years old after he tried to hire her out for pornography. So in an attempt to protect herself, she engaged in retaliatory violence. Piper Lewis is another more recent example of this. She herself was also a child sex trafficking victim who killed a man who was raping her. And she was 15 at the time, and she explained that the person who was raping her was her trafficker, and she relayed all of those allegations, but the police never investigated those allegations. And so to this day, as far as we know, the person that she identified as her trafficker is still out there. He remains free, even though she was charged with first-degree murder. And ultimately, her case resolved with another charge, but part of her sentence that I find remarkable is that she was ordered to pay $150,000 in restitution to her trafficker's family because he was labeled the victim in her case. So going beyond examples of human trafficking, retaliatory violence exists in relation to all types of victimization, including domestic violence. Circling back to the fatal peril Stanford study that Jamie mentioned earlier, these numbers are really staggering. Women who are in California prisons for murder or manslaughter convictions, 74% of those women were in a relationship in the year leading up to their convictions that qualified as intimate partner violence relationships. And then of those women, 66% were determined to be in extreme danger of being killed by their partner. And these numbers come from a danger assessment. So scientifically backed and organized study that's designed to measure these specific things. And when you think about it that way, it really sheds light on who are these women occupying the prisons. So within this domestic violence realm, another perhaps more novel thing that we're beginning to see is this failure to protect theory of prosecution, where a woman is accused of failing to protect her child, even though she is not the one causing harm to her child. A great example of this is Brittany Collins' case, very recent case. She tragically suffered the death of her 2-month-old baby, who was actually killed by his father. But the nightmare didn't end there. She was then prosecuted and convicted of second-degree murder in California, even though her son's murder happened by his father in a place where she wasn't even present. So a little bit of relevant background leading up to her son's death. Brittany was in an abusive relationship with her son's father. He was violent to her even throughout her pregnancy, commenting on at least one occasion that he hurt her with the intent to make her lose the baby. Their relationship continued to be volatile. He used drugs and continued to subject her to violence. On the day of the incident, Collins was in her apartment recovering from childbirth complications. And in a separate room, her son's father was alone caring for their child. After her son's father left, Brittany checked on the baby and found him in a state of medical emergency. He was immediately taken to the hospital, and then tragically, he died from what was determined to be blunt force trauma. This case came out of Kern County, California, and that is where Brittany was convicted of second-degree murder and assault with force likely to cause great bodily injury. Her case went up on appeal, and the Court of Appeal affirmed the murder conviction on the reasoning that she knew that her partner and son's father was an abusive person, and she didn't do enough to protect her baby from him. The case went up to the Supreme Court of California, who reviewed the case and found that the evidence was insufficient to convict her of second-degree murder. The court clarified that for implied malice murder based on a failure to protect theory, the evidence has to show that the parent knew to a substantial degree of certainty that a life-endangering act was occurring or was about to occur, and then they failed to act in conscious disregard for their child's life. And the court concluded that that was not the situation in Brittany's case, that she did not have the right mental state to support a conviction. And so they reversed her conviction and remanded it back for a resentencing. One of the things that the California Supreme Court specifically said is that it is problematic to use the fact that an individual has been abused by their partner to hold that individual criminally liable for their partner's conduct. And that is really the common theme that we're trying to point out and emphasize today, is this concept of being held accountable for something that ultimately is not your fault. So before we move on, I just want to mention one other thing about this failure to protect theory that's becoming more prevalent. I recently saw this play out in a family law context, so we're focused here on criminal context. But there are situations right now where children are being taken from their mothers when the father in the home is accused of criminal conduct. And even though he's been removed from the home and incarcerated, this theory of the mother's failure to protect the children from criminal activity is subjecting her to separation from her children. So this is something that is ongoing and truly a threat to victims as we're speaking today. So forced criminality is another common scenario that leads to the criminalization of victims. Labor trafficking is a great example of this. And I think labor trafficking, we think of often as lawful conduct that you're being forced to do in conditions that are inappropriate or that risk your safety. But there is no requirement that labor trafficking, to qualify as labor trafficking, rather, that the labor has to be legal. Rather, it's coercing the victim to commit a crime or to participate in a crime, and that qualifies as labor trafficking as well. A great example of this is the Victor Rax case that some of you might be familiar with. Victor Rax, in a nutshell, was a well-known member of his community in West Salt Lake City. And he used his influence to orchestrate and carry out a trafficking scheme among young men in his neighborhood. He specifically targeted teen boys in this neighborhood where street crime was prevalent. Often these boys or their family members were undocumented immigrants, and Rax used those factors in his selection of them and his grooming of them, and ultimately in the way that he forced them to commit crimes for him. So a typical scenario looked like Rax paying these boys to do odd jobs for him, taking them to sporting events, giving them gifts, essentially creating these bonds and creating trust with them. And then what this escalated to was Rax taking the young men to a vacant home that Rax owned in the neighborhood where he would sexually abuse them. After that, the next part of the relationship was forcing them to deal drugs for him. So drug dealing specifically in this scenario is the example of the forced criminality. And he used this dynamic to maintain control over his victims. So once they had been abused, he would then use that to say, if you don't participate, if you try to go to law enforcement or tell anyone else about this, I'll discredit you, because I can say that you're gay, that this was, welcome behavior. I'll harm your family members. You're now a criminal yourself because you're dealing drugs. And these are all of the reasons that it wouldn't make sense for you to expose this exploitation. He would then use them to recruit friends in the neighborhood to continue the trafficking scheme. And an interesting fact about this particular case is that the profits from the drug dealing actually paid for the house where he took the victims to be abused. So this case really illustrates the intersection of sexual abuse, forced criminality, and human trafficking. And he was ultimately prosecuted for human trafficking. So that case exemplifies, like I mentioned, the drug dealing. The forced criminality can look like so many different things. Some things that automatically might pop up in your mind are theft, things related to fraud, identity. I think, identity theft, credit card fraud, things like that. It's really an unlimited spectrum of conduct that could qualify as forced criminality. And all of this stems from the power and control dynamic between the perpetrator and the victim. So some of the ways that victims are controlled by their traffickers are very obvious. Physical abuse, sexual abuse, threats. You have to do what I'm telling you, or I will harm you, or I will harm someone you love. The forced criminality, like I mentioned in the Victor Rax case, creates this additional element of, now I have something on you that I can report that just further increases this power and control dynamic. But there are other ways that traffickers utilize their power and control over their victims that are not so obvious. And this wheel does a great job of kind of exploring all of those possibilities. You'll see isolation on the wheel, keeping their victims confined, away from public places, certainly away from any kind of support system, using their own privilege to make their victims feel as if they because the trafficker is superior, the victim deserves to be controlled for whatever reason, gender, age, nationality. So when we're working with clients that might fall into this category, this wheel can be a really helpful tool in trying to identify what might be going on in various circumstances that would qualify as trafficking, even if not immediately apparent. Another example of forced criminality is this study that we want to take a minute to talk about. That the trick roll study is what we refer to it as. And trick rolls, as many of you probably know, are robberies of sex buyers. So this particular study just it looked at 467 trick roll cases over a 1-year period in Las Vegas specifically. And even though this number might not shock you, I want you to really think about what this study revealed. It found that 36% of the identified suspects in the trick roll cases, so the people who were accused of performing the robberies during a sex buying situation, were actually known victims of trafficking. The 36% was identified based on, databases of known victims and other readily available tools for law enforcement. So potentially there could have been more. But of those 36%, all of them were female, and a quarter of them were Black women. So even though 36% might not sound startling, it really is notable that what we know about those cases then is that these trafficking victims were forced to commit the robberies at the instruction of their traffickers, and they found that preferable to whatever the consequences would have been. Maybe by earning more money, it helped them meet their quota and avoid abuse by their trafficker, or their traffickers may have explicitly threatened, if you don't do this and bring back more money, this is the harm you'll face. So it's an interesting illustration of forced criminality, and one that's very common. Another example of criminalization of victims is crimes by association. So similar to forced criminality, in that victims become involved in a criminal offense because of the power and control someone else has over them. But it's different in that the criminalized victims don't even have to take any action to be guilty. So unlike the trick roll cases where an act of robbery is performed just by mere association, you could be held liable for a crime that was committed by your perpetrator. Every state in the nation has an accomplice liability statute that allows you to be punished for a crime if you can be deemed as assisting or supporting another person who actually commits the crime. Carolyn Moore is a good case, or a good example of this. Her case in Louisiana, she was in a car while her abuser was committing a robbery, and she was convicted as his accomplice, even though she wasn't at the scene where the robbery was committed. She wasn't involved in actually committing the robbery or the murders in any way under a felony murder theory. She was convicted even though she explained that her presence and any theory of guilt by association was all because he threatened her, and her life was at risk if she didn't follow his instructions. So those are some things to think about when trying to figure out how this situation comes to be, where we have a survivor facing time in prison and facing the re-traumatization that presents for them.
Thank you so much, Chelsea. Now we're going to talk about the impact of incarceration on these individuals who are in the carceral system. So there's, we cannot, there's so much to talk about here, but among the things that are, the impacts are things like the environment of being in the carceral setting is extremely traumatic and re-traumatizes individuals, exacerbates their trauma, where they actually leave with more trauma than they arrived. And some of examples are that there's routine strip searches, isolation, and isolation is often used as a form of punishment for those who report sexual assault. And there's extensive violence within carceral settings, both at the hand of other individuals who are incarcerated and also at the hands of the correctional staff. There's also very limited mental health treatment in carceral settings, which means that individuals, we already see that, as we talked about earlier, the vast majority of individuals in the carceral system have a history of trauma. They have adverse childhood experiences. They've had all these different traumatic experiences prior to their incarceration. They're very unlikely to be able to access any type of mental health treatment while they're there. And if they are, it's pretty limited. Um, and so they're not going to be able to get that treatment until their eventual release. There are lots of programs, and every system is very different. Even within California, we see vast differences county by county. So it really even depends on where you are incarcerated, of what types of programming or treatment you might have access to. And a lot of individuals that I've worked with have received programming that has been really helpful within carceral settings. So I'm not saying it's not possible. A lot of folks also do their own work while in carceral settings and really overcome tremendous trauma just by their own healing work. And that could look in a number of different ways. I have clients who are poets who write poetry, clients who write books while they're there. I mean, there's so many different ways that people can pursue their own healing, but in terms of clinical treatment, is extremely limited. Whereas like if they were outside, there's still limited access to treatment, but certainly a lot more than you find on the inside. And then there is pervasive sexual assault in our jails and prisons, which means that people are experiencing additional traumatic experiences while they're in that system. And a little more on that is that it's estimated that more than 3,500 women are sexually abused by prison and jail staff each year. And this is just federal. That number is just federal. Another data point is that 40% of male and female inmates experience physical or sexual violence while in prison. And then there was this recent case in California. Those of you who are in California, many were involved in supporting survivors through this trial that just completed last year. Actually this year. And that in that case, an individual, correctional officer named Gregory Rodriguez was accused of sexual assault for a decade before he faced trial. And individuals who had reported the abuse ended up in solitary confinement and were punished. And ultimately, he was tried and convicted of 64 counts of sexual abuse. And while this case is an example of somebody actually being held accountable for their actions, it happened far too late and is really one of very few cases that we've seen. In fact, despite the fact that there have been hundreds of complaints in California for abuse within our state legal prison system, he is one of only 4 officers that is documented to have faced criminal charges for his abuse. Of course, this also impacts families and communities. Children of incarcerated parents face all kinds of long-term harm, psychological harm from having their parent locked up. Um, the vast majority of women in prison and many of the men in prison are parents, and we're perpetuating generational cycles of trauma because of this criminalization of victims and survivors. And then when folks get out, they face additional barriers. They have a hard time because of their record, in the same way that anybody with a record faces challenges, including a difficulty getting housing, employment, as a result, difficulty becoming financially stable, and the social stigma that comes along with a record. There's also really high rates of recidivism in the US. Up to 80% of formerly incarcerated individuals are rearrested. And there's a whole, there's lots of studies, but the study that this data point is from, takes a deep dive into why that is. And the summary of that is that the system is people are really set up to fail when they're on probation. There are ridiculous requirements that people have to fulfill and follow in order to stay out of trouble and to not get rearrested. And it, it becomes extremely difficult for folks with all these barriers they have in terms of getting housing and employment and financial stability to be able to fulfill the terms of their probation or their parole. And therefore, they often end up back in that same system. And they may engage in all those behaviors that we talked about earlier in terms of behaviors related to economic instability or coping with their trauma. So what has our legal system done to acknowledge and address this? Chelsea is gonna talk about this next.
Fortunately, in recent years, there has been a shift toward new laws that consider trauma and victimization throughout every phase of a criminal case. And that's a great thing because it indicates that stakeholders in the criminal justice system are becoming more aware about the connection between victimization and criminal activity. So it isn't just as simple as arresting someone who has committed a crime and labeling them a criminal. It's more complex than that. So while in an ideal world, the ultimate goal would be to avoid criminal charges for victims, these laws are a step in the right direction, taking victimization into account when determining if victims should be charged at all or what they should be charged with, what evidence should be included when the case is being litigated, and then how sentencing procedures should take victimization into account when crafting whatever type of punishment is going to be imposed. So some examples of this include affirmative defenses. And as most of you probably know, affirmative defenses arise in a situation where someone has been charged, the person admits to the conduct that led to the charge, but there is a legal explanation to justify the actions that negates their liability. So we've already talked about some examples of that today in Crystal Kaiser's case. Not contesting the murder itself, but the reason the murder happened is highly relevant to whether or not she is culpable. California's Justice for Survivors Act recently expanded California's affirmative defense to include not only victims of human trafficking, but victims of intimate partner violence and sexual violence. At least 38 states have enacted affirmative defenses for human trafficking victims. And so we're seeing progress, certainly. But many of these defenses have limitations. Often they're only applicable for specific types of offenses, or they're only available to certain types of victims. So in that way, California's affirmative defense provides more coverage than some other statutes do. Diving in a little bit further into California's affirmative defense, this is available to anyone who could establish that they were coerced to commit the offense as a direct result of their victimization, whether that's human trafficking or other types of violence, and that they had a reasonable fear of harm. So the burden that is on someone trying to assert this defense is establishing those two things by a preponderance of the evidence. California is the only state that, as far as I know, that encompasses victims that are not just human trafficking victims. So California is doing great work, but far from perfect. One of the limitations of this affirmative defense specifically is that it's only available for nonviolent felonies. So there is still work to be done in expanding the remedies that do exist. Another thing that's important to touch on in this context is safe harbor laws. Safe harbor laws are the legislative response to the pervasive criminalization of youth trafficking victims. The idea behind safe harbor laws is that they're supposed to insulate victims from prosecution and punishment entirely, and instead, once they're identified as a victim, redirect them to services that are needed. So the ultimate goal there is avoiding placement in the criminal system at all. And there's different ways that can be done, and different safe harbor laws look different. Sometimes it's total immunity in exchange for sharing your story, your promised protection instead of prosecution. Sometimes it's diverting the case into a program where if you can complete certain conditions, you'll receive services and ultimately not be prosecuted after successful completion of a diversion program. So 29 states and DC have safe harbor laws that at a minimum prohibit the criminalization of child sex trafficking victims for prostitution offenses. The 21 remaining states still have laws that allow for child sex trafficking victims to be prosecuted for prosecution, even though as minors, they are de facto victims of trafficking, no matter their conduct. So again, this is a theme. We're moving in the right direction, but it's far from perfect. From a prosecutorial and public safety standpoint, safe harbor laws go beyond just addressing additional harm to victims, and for that reason, they're often appealing to government stakeholders because they can increase successful investigation of crimes and prosecution of true perpetrators. By allowing victims to share their stories without that threat of prosecution. Jamie mentioned earlier that we've both witnessed cases where law enforcement and prosecuting agencies knowingly arrest and charge human trafficking victims with crime, with the goal of coercing them to share their story so they can gather more evidence on the trafficking victim's perpetrator. So really, what this exemplifies is there's a need to treat victims differently, to not label them as criminals initially and leave them feeling like they have no choice but to risk their own safety by giving law enforcement what they want. Ultimately, that's not a productive process, and that's what safe harbor laws can teach us. Now, just like we've mentioned for every one of these remedies, it's certainly a step in the right direction towards reducing criminalization of victims. But in many states, these safe harbor laws are still falling short and need to be expanded. They're valuable in that they reflect an increased understanding that trafficking victims shouldn't face criminal liability, but there's more work to do because really they should insulate victims of all crimes related to their exploitation, not just prostitution. And they should also extend to more victims, not just human trafficking, but all types of abuse and assaults, particularly when it comes to minors. Shared Hope International, who I'm sure many of you are familiar with, they conduct an annual kind of like comprehensive analysis of state statutes. And in 2023, they grade as part of this process, they grade states based on the safe harbor laws that they've enacted. So they gave 32 states failing grades for still criminalizing minors engaged in prostitution. And found that only one state, Tennessee, earned an A for having effective safe harbor laws. So still a ways to go. Another example of legal reforms that can address the problems created by criminalization are sentencing and resentencing laws. And this could really be a training in and of itself, a presentation on just these laws that are, evolving and constantly improving. But what you can see here from this slide, primarily, the point is that courts are being put in a situation where they have to consider victimization as a mitigating factor when an individual comes before them for sentencing. For example, in California, the Justice for Survivors Act, again, mandates low-term sentencing when trauma contributed to the offense. There are also increasing efforts to account for criminalized victims who have already been sentenced and are serving their time by giving them a vehicle to go back to court for resentencing. There's something happening in Georgia right now that's really interesting that gives survivors an opportunity to go back to court if they can tie their crime to domestic abuse. This gives them a way to address the wrong that was done previously. Another thing that is designed to act as a remedy for the wrong that's already happened are vacatur and expungement laws. Those are forms of post-conviction relief that help try to repair the harm that have been experienced by criminalized victims. Prosecutions that shouldn't have happened in the first place, but now there is acknowledgement of that, and there is a way to enable survivors to remove the barriers that they face into valuable employment, education, housing, public benefits, whatever it may be. Vacatur allows them to entirely remove that conviction from their record so that they're not viewed as a convicted criminal going forward. All states except Maine and Iowa have enacted laws that enable trafficking survivors to seal, vacate, or expunge their criminal convictions. So that's major progress. This map shows in yellow what states offer some type of criminal record relief. As with all of the relief we've talked about today, it's nuanced state by state. It varies based on the availability, varies based on the crime that was committed, the type of abuse inflicted. So we'll use California as again as an example because that's the one that we're most familiar with. California's vacatur statute provides post-conviction relief for survivors of trafficking and again, victims of intimate partner violence and sexual violence. But they're limited to seeking relief for only non-violent offenses and arrests. That person who's seeking or petitioning the court for relief has the burden of establishing that they were a victim of one of the delineated offenses at the time of their crime, that their arrest was a direct result, and that vacatur is in the best interest of justice. Now, one thing I want to add quickly is that California's law includes a provision that if the petitioner can satisfy each of those elements, not only are they entitled to vacatur of their conviction or their arrest from their record, but the court has to make a finding that the individual lacked the requisite intent to commit the offense and vacate the conviction as invalid because of a legal defect. That is a significant acknowledgement that the petitioner never should have been convicted of a crime, and it's critical to helping them construct the narrative that they are not a criminal, but a victim entitled to relief. So we'd like to see more of that in other states. Post-conviction relief, just like all the other relief, really has room for improvement. So like I just mentioned, California's law ideally would extend to violent crimes like Miss Kaiser's case and some of the others that we've talked about. That retaliatory violence is a very real thing that sometimes is excluded entirely from the conversation about relief. Standardizing laws would be helpful so that it's not so hard to advise clients in different states and help them seek the relief. Lots of room for progress, but for now, one tool that might be helpful for you is this interactive map that is here. You can the link is there at the bottom if you're interested in using it. But Justice for Youth Survivors Initiative has this documentation. Essentially, it's a bank of laws across the country that somehow reduce the criminalization of survivors of gender-based violence. So you can navigate by state, and you can also navigate by type of relief. So you can see safe harbor laws that exist, self-defense laws, sentencing reduction laws, expungement and vacatur laws. And this kind of collection of where we are today is really critical to evaluate what room we have for improvement going forward.
And I just want to add, thank you so much, Chelsea. That was really great. I just want to add that the other map that we showed earlier, the Freedom Network map, is also an interactive map. If you want to look up your state's vacatur law, it's a really great resource. And if you just go to Freedom Network Survivor Reentry Project, that's where you can find it. And also, if you're looking to refer survivors to vacatur services, that's a great place to start. So finally, as we wrap up, and I do see we are at the hour, so we'll, wrap up this relatively quickly and then take some questions, is, talking about what it would look like to have a more trauma-informed approach in our criminal legal system. So just like very preliminarily, just highlighting a few things of what it means to be trauma-informed. We have this SAMHSA 4 Rs of a trauma-informed approach: realize, recognize, respond, resist. These are like foundational to what it means to be trauma-informed. And additionally, the 6 principles of a trauma-informed approach: safety, trustworthiness and transparency, peer support, collaboration and mutuality, empowerment, voice and choice, and cultural and historical gender issues. Ideally, any response to survivors who are in the criminal legal system at any stage should incorporate these aspects into that response. So what would it look like to have a more trauma-informed legal system? A starting point is to have a criminal legal system that understands trauma. What we know as attorneys in the field is that there rarely is education on trauma in law school or even in legal education settings. And so it would require having that education at the law school level where attorneys, before becoming attorneys, learn about trauma, learn what it means to be trauma informed, because those are the attorneys that go on to be prosecutors, defense attorneys, judges, and it would give them that grounding information before they step out into the field. And of course, there should be continuing education throughout their careers on these issues. Um, in addition, everybody in the criminal legal system needs this type of education. Law enforcement, um, correctional staff, probation, parole. There's just very limited education in, again, varies everywhere, but really limited education on trauma and trauma-informed practices. And that's something that we really need to grow. If you're part of any of these types of institutions and are interested in further training, please let me know. Be happy to discuss that with you and what that looks like, because it's something I'm really passionate about. In addition, we need to identify folks who are victims when they're arrested. Sorry about that. This is a screenshot from just a random sting operation case. And I did this because I look at these every single time I see, sting operation happen, all these people are arrested. I look at these pictures and I say, I guarantee you that some of the folks that were arrested are victims. I guarantee you in this group that there are people who are victims of trafficking, of other types of crimes, and yet they're being broadcast out to the world as somebody who is actually, being labeled a criminal when in fact they are victims, and the system should treat them as a criminal, as a victim, I'm sorry. In addition, we need specialized units in our defense agencies who understand the different forms of victimization, not just exploitation, but abuse, assault, exploitation, human trafficking. One really great example is the Legal Aid Society of New York, which is New York City's primary public defender. It actually has multiple specialized units, but one of them is the Exploitation Intervention Project. And that unit has public defenders and a whole staff of people that are trained to address, from a really holistic perspective, victims of gender-based violence and human trafficking, and help bring that victimization into the case in terms of its relevance to the criminal prosecution. And these are people who are trained, trauma-informed, and equipped to serve this client population. And even beyond, not everybody can have that specialized unit regardless. Defense attorneys really should highlight their clients' trauma and victimization as it relates to the facts of their case. Depending on your state's laws, as Chelsea talked about, there's all these different laws out there that make it relevant. But even if your state doesn't have those laws, it could be relevant for a number of other reasons, including their mental capacity to commit the crime. It could be mitigating information, but regardless, it's something that, what I've heard survivors say over and over again is, it was never a part of my case, and I didn't have a chance to tell my story. And really, that's extremely important for judges and juries to understand, who is this person that's being charged with this crime and why did the crime even occur? In addition, we need trauma-informed prosecutions. We hear a lot about victim-centered prosecutions, and what that tends to mean most often is the person who is labeled the victim of the crime is placed at the center of the prosecution, but we don't see that same response when the person being charged with a crime is also a victim. And we really need to shift our understanding and shift away from this binary way of looking at things of like, this person's a victim and this person's a criminal. We have to move away from that to understand that there's a lot of people who are charged with crimes who are also victims of crime. We also need to support our alternatives to incarceration. And there's a lot of different models out there and a lot of different ways to explore this. Human trafficking collaborative courts are one example among many of ways to divert people out of the criminal legal system, or at least give them a path out of incarceration into programs and services for survivors. I firmly believe that this is a population that is not a threat to society. It's a population that has experienced significant trauma, and with treatment and support and services, they will not continue to be in this system. But without that, they won't have that path out. And finally, we have to change the system. Now, we've seen this incredible expansion of laws. There's a lot more work to be done, and Chelsea highlighted some of the ways that we need to change the laws, but we really need to, expand the safe harbor laws so that every state has one, that they're inclusive and go beyond charges of prostitution, expand our affirmative defenses, expand our sentencing, resentencing laws, and our vacatur and expungement laws to make them more robust and inclusive. And I know a lot of the folks here are doing that policy work, and that work has paid off because those maps look incredibly different now than they did 5 or 10 years ago because of the work that so many advocates are doing around the country. And then we need to look at some of these other laws, look at felony murder and accomplice liability and create exceptions to those laws when the individual being charged with that crime is a victim of abuse, assault, or human trafficking. So just to wrap up, we talked about we need alternatives to incarceration and we need trauma-informed practices that really reduce the harm to criminalized individuals and focus not on locking them up, instead in fostering their recovery. And these legal reforms must prioritize the needs and dignity of criminalized survivors. And I hope that the folks here will collaborate locally and nationally with policymakers, with legal professionals to advocate for systemic change. And as we wrap up, here is our contact information if you want to reach out. You're also welcome to request a copy of the article that we mentioned. If you just scan this QR code, it'll bring you to a very short Google form that you can fill out, and that way we can send you the article when it comes out. It should be coming out any day now. And with that, let us just look at the Q&A to see if we have any questions. But thank you for those who do have to jump off. Thank you so much for being here. We so appreciate you being a part of this conversation with us, and we look forward to having you join future webinars. And let's look at I'm going to go to one of the quicker questions first, which is, has there been any process on federal vacatur? There have been multiple attempts at a federal vacatur law, at least 3 that I know of, probably more. There was a bill last year that made it farther than any had before, which was really exciting. It did not manage to get passed before the end of the last session of Congress, and so it was reintroduced against this year. It is moving quickly, and we are really hopeful that it will pass. But up until that law passes, there actually is no way to vacate a federal crime like there are in almost every state. But it's a great question. And if you want to know more about that, reach out to me offline and I can send you some more information about that bill. Okay, so I see another question. This person says, I've represented criminalized survivors for 7 years in record clearing cases, many charged with trafficking, and wondering if you can speak about the intersection of the trafficking laws and criminalization, because minor trafficking cases do not require a means, so meaning the individual is a minor, and the means being force, fraud, or coercion. Victim adults can be victimized alongside minors, but law enforcement separate minors from adults and charge the adults as traffickers and direct the minors to services as victims. And that is so true. Even where adult women are being trafficked, and the only difference is their age. Also, there are complex trauma bonds with traffickers that might make women who've been in the situation a long time unwilling to testify, making them more likely to plead guilty rather than go against their traffickers. Adult victims end up with trafficking charges are on sex offender registries, even though they are also victims. And the question is, what's being done to identify adult victims in such cases? Which conversations are happening in terms of arresting decisions and prosecutorial discretion? That is such an important question, and I'm really glad you asked. The answer is just like I think a lot of the other answers is it really, really depends. In every single jurisdiction is different. I'm working on cases involving exactly what you're describing as an expert witness around the state of California, and I'm seeing really different things throughout the state. I'm seeing in some jurisdictions, the prosecution may acknowledge that the individual is a victim and in a lot of these cases, they're saying, I know this person's a victim, but I want them to testify against their trafficker. And so essentially they're holding these charges over them, knowing that they're a victim because they want to coerce their testimony, which is ridiculous and shouldn't be happening. In those cases, every state's law is different. Those individuals may be entitled to an affirmative defense if they're in a state like California. Our affirmative defense in California does apply to the crime of human trafficking, so you can assert that. And that doesn't require you to testify against your trafficker, but it does require you to testify about your own experience as a victim of trafficking. And sometimes for some victims, that might be a distinction without a difference. There is certainly negotiation that can happen outside of trial between defense attorneys and prosecutors, uh, identifying and advocating for this person as a victim of trafficking, and then bringing in expert witnesses to educate the prosecution about their victimization, about those trauma bonds that you referenced, about how they were coerced to commit the crime, and advocating for a more just outcome for those individuals. Um, but it is absolutely something that is unfortunately extremely prevalent. I'm really glad you raised that. So thank you for that. Chelsea, I know you've worked on these cases as well. Do you have anything to add to that?
Yes, and so much to add, but you're exactly right. You've identified the coercive nature there in the dynamic between prosecutors and the individuals charged. And one thing that is true, especially in federal court, is what these victim defendants are facing are mandatory minimum sentences that for young women could put them into prison for the rest of their childbearing years. Their chance at developing careers vanish. Their connections to their support networks become hard to maintain, because this is like the crucial years of their young adult lives that they have to choose. Do I give that away, or do I risk my safety? And really, like, these are neither choice is reasonable. So not a helpful response in the sense that I have great advice that you can implement right away. But I think the answer is we have to invest and spend time in targeting these bigger problems, which are the laws themselves, reaching out to the stakeholders and the people who have the power to change what the law is really the answer in so many of these cases. But obviously that takes time and the type of commitment that allows you to survive the painful years of rejection and all of the blood, sweat, and tears that go with that. Kayla asked a question in the chat, Jamie, that sort of raises similar thoughts from me. As vacatur practitioners, Jamie and I can tell you all kinds of stories about the realities of actually accomplishing vacatur and then effectuating the vacatur order. And similar to what you're talking about here, Kayla, we certainly can sympathize. So Kayla in the chat, as you can see, mentioned that she's had a problem with clients who have multiple convictions in different counties, and then the different vacatur laws having provisions that there are time limitations on when you can seek vacatur. So as a result, she's had to go in reverse order of convictions, which means that their clients' convictions are vacated sequentially. And so if you have multiple convictions over multiple jurisdictions, the process can take literally years, preventing any sort of relief in the immediate future. And Jamie probably has thoughts and comments on this, but I think this is also an example of where lobbying and advocating for real change in the law is what is needed.
I completely agree, Chelsea, and Kayla just put that in the chat as well, is that, the really only solution to that is a legislative one of removing that from the statutes. And you know, for those of you who might be familiar, Polaris Project has a state report card of the vacatur laws around the United States. I highly recommend checking that out. And those are the types of things that they talk about, and they give states a grade. And you know, your state may have gotten a C or a D or an F. I know California used to have a D, and I think we have a C now because of the hard work of the advocates that have been working to change these laws. And that report card is a great tool as an advocate to go to your legislator and say, we got an F, we need to do better. Just because we have a law doesn't mean it's helping survivors. And here's the problem with that. And, you know, I've also seen the power of survivors, individuals with lived experience to change these laws. In California, we had one bill that came about from an author that you would not expect to author a law on helping survivors of trafficking with a criminal record reform. But a survivor that was a constituent went to her elected official and said, I am having this problem with California's vacatur law. I can't use it, and here's why. And this individual authored a law and was a huge champion for this, not just for the survivor, but all survivors. So, you know, there's such an immense need for folks with lived experience. If you're facing a barrier, to either reach out to other advocates and organizations, or you know, to work with your elected officials to remove these barriers. I think that's all the questions that I see, but I do see a couple questions just about, and I apologize, I meant to mention this at the beginning, about both getting a copy of the slides and getting a copy of the recording, and we will be distributing both after this, so we will send those around to everybody who registered, so you'll get that. And you know, if you are part of an agency, organization, institution that wants further training on any of the topics we've discussed today, please, by all means, reach out. We would love to do this training or something similar, or another topic for your audience. It's, of course, a subject that we're both really passionate about and want to reach as many people as possible. And especially among all prosecutors and defense attorneys, we want to give training that is really tailored to those audiences, so that they can understand these dynamics and spot them in their cases. And just one last thing is I see a note that Amara Legal Center in DC also has a state-by-state vacatur. I don't know if it's a practice guide or a document, but something to check out there for Amara Legal Center. Thank you all so much for being here. Thank you for all the work that you are doing in this space. We're so grateful for each one of you, and we hope you have a great rest of your day. And thank you so much, Chelsea. It's always great to work with you.
Thank you, Jamie.
Take care, everyone.